Good morning, ladies and gentlemen. Welcome to the first EUROMETAL Still webinar this year. I'm Alexander Julius, and I have the great pleasure welcome two distinguished speakers telling us a bit more about the latest revision of the European steel safeguards effective from 1st April this year. Alexander Siryk, CEO of Metals Consulting International, will initially explain to us what has changed with the latest revision. What are the most affected areas and what is the expected prolongation framework? After that, Lars, Hillmann, lawyer with Cattwyk and specialized on international trade law, will reflect on the interplay of safeguards with other trade measures, deliberation of the quota system, and how to protect the declarants in terms of contractual implications. We have about 20 minutes time per speaker, which will be followed by a 20-minute Q&A for you as our today's audience. So, Alexander, the floor is yours.
Thank you, Alexander, for introduction. And so let's start with the first part of the discussion, the current status of the quota utilization. Then we will go to the context of EU steel tariff quotas, just to put the wider frame, check changes which happened to the system, and also implications for the market and for specific products. So, just to bring everyone on the same page, this is an extract from reporting, and EUROMETAL members, they received it every week. You have a report on imported volumes to go through what kind of products we have in the scope of the quota, in the scope of the reporting, because there are some more steel products which are included into restrictions, some semi-finished products, pig iron, as you might know, and others. So here we are talking about flat products, and there are certain types of groupings within those flat products, because several categories by definition we have in other products like electrical steel mill products, but we bring them as a separate category where we combine some niche applications, niche products to follow the bulk markets and commodities. So we have flat as big part, and since 1st of April, there are two subcategories, 1A, 1B. So 1B, there are products from narrow strips coming from the tariff codes 7212. And we have cold rolled products, metal coated, including hot dip galvanized, electrically galvanized, and others, organic coated, and hot rolled plates. This abbreviation, HRP, those are hot rolled plates. We have longs, also carbon. We have stainless, which are grouped into, say, one category, and tubes, pipes, hollow sections. So this is how we a little bit reshuffle the categories between different products, between the categories which are tracked by European Commission within the tariff quota system. So what is happening now with the quota? And we providing the information on the weekly basis. We also check several parameters. And this is one of the views, one of the general views, because we also have other numbers and so on, just to have you quite practical and detailed information. But over here, you see how quotas are developing and what is their utilization rate. One step over here, which often produces questions, what is happening at the beginning of the periods or around some like dates at the beginnings of some first decade or first 3 weeks of the quota periods? Because quotas, they are increasing, and there is one step. And this is one of the areas where changes and modifications happened. Because from the very beginning, European quotas, they are split into annual periods. And to manage the volumes better and smoother, then in around 2020, 2021 appeared quarterly periods, and within one annual period, residual quarter can be shifted. And this is happening not strictly in the second week of the next reporting period or the first decade, but around those dates. So you see the volumes which were not used in the previous quarter, and everything is just expiring at the end of annual period, which is 30th of June. So this was the area of modifications which you see what is happening, how volumes are increasing, because many country-specific quotas, they remain and they migrate through the same year. And for the current period, we just highlighted something comparable from the point of view of dates. And you see from this picture, it's quite difficult to say something about absolute volumes, what is happening, and so on. But utilization rates, you see, they are quite similar. So market activity, import market activity remains high. To help you to check what is going on, we also subtract this data, just giving another view. So over here, every week, you see which is material coming. It is arithmetical calculations, and this is another point where I would like to bring you attention. And I know that Lars is going maybe to speak, and Alexander to speak a little bit more about this, that from time to time, we see the situation when those weekly quotas then negative. So you cannot calculate what was imported in course of the week, just checking like incoming balance and outgoing balance. Why? Because it happens in the system, and don't be confused, because it happens in the system that some applications, some customs declarations, they are withdrawn. And that is where we try to not put negative figures over there. We just put them at zero. But this is just because of cancellation of certain declarations. And there are other views, though, for every product, for every category, because declaring the products to customs, you know that there are specific order numbers, and you get also specific quotas because they are split on the country-wise and different positions and so on. But also from this view, you see that average figures over for the first almost 2 months, not full 2 months, generally a little bit higher for the imports than for the previous periods. So you see as an average temperature, we see that as the averages long term, they are a little bit higher. So this is the current status of what was happening and why it was happening, and a couple of words what is supposed to happen next. Now we are in this green bubble. And on the at the beginning of the slides, on the upper half of the slides, generally the actions from which all this hustle started the previous time are highlighted. So going back into 2017, there was a very like situation with the current one. So the United States, they initiated measures addressing imports of steel and aluminum. And certain counteraction started on the European side, because access to the European market, you know that there are zero import tariffs for the most of the categories, at least for steel products. And European market is one of the largest global markets, and the trading of volumes that can be redirected from the US market. European Commission started also own investigations and own measurements. Those measurements, those investigations, they were prolonged and modified in course of the dates. But you see that the story is already almost 10-year-old story. And now we are in the period of transponomics on the American side, with all the volatilities, changes, weekly announcements about modifications. So very volatile framework. And on 24th of March, European Commission adjusted and refined. This is direct wording from the document, because the prolongation period till 2026, it happened in 2024. So there was a framework already, basically setting up the SEN for the next 2 years. And these documents, it adjusts and refines just to improve the management, not even completing the annual period. So we see that the period starts from the last quarter of the previous period. And what is going to happen in course of the future steel action plan? You know that there is an ongoing discussion within the European Commission, different associations, Eurofer, EUROMETAL, big players in the market. But what was already highlighted that by the third quarter of 2025, European Commission will give a proposal for a trade measure which is going to replace the steel safeguards. Why is this happening? I think that Lars may also touch this topic, that there are WTO rules which regulates what kind of actions and duration of actions and direction of special actions can be taken within the framework of World Trade Organization. So what was changed? And you see that there are several directions. Basically, just reviewing the documents, we tried to put the most important ones, but I see that maybe there are some minor things remain, but what are the big points? First of all, liberalization rate. So this liberalization rate or liberation rate of quotas, it was reduced already in 2026 prolongation, which means in 2024. And it was further reduced to almost 0% in the latest revision. What means this liberalization rate? This means that every year from 2018, for every following consequent period, there was a larger number of imports allowed to the market, which was contrary to the market development. Then several absolute volumes of quotas were reviewed. New category was established. It's quite a small niche product, but some niche products, they really suffer because they were brought to the larger categories. So there was a story with stainless pipes, for example, where you have big volumes of carbon products immediately occupying the complete quota, not allowing some niche players to bring their material. So this is also from time to time, it is getting modified. Also, once again, there is a remapping of developing countries. So there is a certain principle, the 3% threshold, to change the listing. So this is checked, and this is this was also updated. And two essential changes, which are really impacting on the effective volumes accessible to certain players, to certain markets. It's carryover of unused quotas. That is exactly this step which I shown to you, what was happening every quarter after the first quarter. And this approach was changed, so that is not anymore a general rule, or there were in the previous edition, there were like different regimes. And right now, there are products where there is no access to the residual quotas. There are categories where access remained, and there are categories where there were no changes. So there are around 7 categories where there are no changes, and we are going to show this in the more details. And then another essential modification, which was initiated in the previous period for hot rolled coils, because there is an others category. You have for the quotas, you have country-specific categories, and you have also others, which do not have this specific quotas defined for the country. And typically it was just in the first hours of the new quota release, it was taken by bulk volumes of lower cost importers. And to avoid this kind of situation, so there was this jump in the volumes, to establish more gradual supplies, better planning, to allow other players to participate in the European market. A cap was introduced in the prolongation document, and now it covers already more than half of the categories, this cap. So let's go through the points with a little bit more details. The first point was reduction of the imports liberation rates, and you see that to not confuse you, 2024 is skipped from this document because we have our own calculation for the market development, but just to follow the official logic of Eurofair, what is included in the documents, we stop at 2023, where you see that market was declining and share of imports was increasing in the long-term perspective. That was a reason to react in 2024 with all this adjustment. But finally, in the new document for 2025, if you compare with 2023, quotas, they reduced. You see that for many categories, there is a reduction with several approaches, which they were reduced, because one of those reduction elements, it was it was a deletion of redistribution of the volumes coming from the ban of Russian material, for example, and so there are several factors which are impacting these volumes. But effectively, the total quota numbers for 2024 are supposed to decrease. But you still see that it's much higher. So the total volume is much higher than in 2020. So it's much higher when the system was introduced. But from the market, you see that the market is, I would say, just carefully in stagnation. But it's really challenging situation right now for the consumer industries, for the European market. So another point is review of the developing countries lists, and over here you see that the countries which got more like protected, the categories from the countries which are more protected are highlighted with red, and there are some categories which were liberalized. And there are some important major changes, like for India, like for China, but overall you see that the picture remains quite stable, because without highlights, those cells, they remained similar to the previous periods. And the most disturbing discussions and questions are about Indonesia, Malaysia, and Vietnam. What is allowed, what is not allowed, and you see the modifications. But this is electrical steel, category 3B. Just also a little bit to guide you. There are categories, and they are not grouped into the same category, in the same product groups. Therefore, on the top, you see some, if you are not familiar with categories of the quotas, on the top of the slide, you see certain guidance. What are the categories? And we use a color code over here. So you have flat carbon, this would be dark gray. Long carbon categories would be lighter gray color. Stainless products, those are the categories. So you can have an idea what would be the category which is more liberalized or more protected by now. And to follow the same logic, there are two other elements which we touched in terms of modification. So you see the same guideline, you see the same categories, and then what is happening with residual quotas. So you see you have categories, and you see that for the most categories there is no excess. There is no excess. Here in the first cell, we have 1A, because for 1A there is no access, and for 1B there is access, so there's a different regime. But you should keep in mind this 1B category is a niche product and quite a low volume quota for this niche product. So talking about big developments, it's still 1A. And you see that cap is not anymore 15%. There are variable between the categories depending on the import market situation. So caps, they vary from 13% to 30%. So from 1.3 to 3.0%. And also for, let's say, bulk categories, product categories, there is also no anymore carryover of tariff rate quotas for the next periods. So they remained like from the big categories for 4B, those are hot dip galvanized products. But overall, you see that that was development of the system. To be fair, it might sound as a quite dramatic change for if you are importer. But coming back to what was rumored and discussed before implementation, so here we try to wrap up what was discussed, what was published, what was rumored. It's a very, very light version, which for comparing to what was requested by the European steel industry, because what was rumored is that reduction of volumes supposed to be by 25-50% for some of the categories. We see that as implementation part, it's happened just partially. Then it was also requested to increase import tariff for the volumes which are exceeding the tariff quotas for more than 25%. They retain, so there is no change. And this expansion of cap beyond hot rolled coils category, it was, as you saw, it's implemented partially. So there are some categories which don't have this cap depending on the situation. And it was also requested to stop tariff rate quotas carry over, which was also implemented only partially. And there was also a request for more country-specific quotas, reduction of residual quotas, so it was also implemented partially. Also, what was also discussed and rumored that individual quotas for Chinese material, they were requested, but it was there are some orders which belong to imports from China, but generally it was not widely introduced. Implications for of this developments for the markets. I'm just checking the timeline. So we have the last two slides and two examples. So what does it practically mean? And as soon as there are many categories, and I know that you import a lot of material in the different categories, here we have analysis of flat products. And you see how the general logic is developing and evolving. So you have tariff rate quota, and we calculated this for 2024 for the second half of the year, just to have more fair comparison, to not annualize the volumes from the first period and so on. How would second half, where we have clean already periods, look like? And you see that there is a small reduction comparably in the nominal quotas. Then you have the fact that actual import was even lower than the quota, because many country-specific quotas, they are not used in the periods. So many countries, they just utilize only some shares of the imports that are allowed to them. Then, and this is already generic calculation, because this others cap. So if we assume that from the previous actual imports, countries would not be allowed to import this material, this may lead to reduction of certain volume, and you see that we are losing almost 2 million because of this, because of limitations for the players with viable parities, which have visible imports. And another factor which must be also brought into this picture is that there is another instrument which is also activated and actively used by European Commission and by applications of Eurofair. It's also anti-dumping investigations. And for example, if this is happening with hot-rolled coils from Japan, Egypt, and Vietnam, this will further reduce, and from actual imports, they may cause around 25% of the market loss, subject to various factors, because there are also parities, there are other suppliers, and this is what this may happen with the flexibility of this. And of course, the situation would differ from product to product. So if you take this, what we combined in the flats category, you would see smaller applications for pre-painted material and much larger applications for hot-rolled coils and cold coils. Just to wrap up shortly all the theses. So we have the system which is addressing this, which addresses vulnerabilities of the market, establishing protection for the European industry. The system was developing through the last years, and in the most recent edition, it addresses lower liberalization rates, it reduces absolute volumes of quotas, and modifying developing countries list, also working with residual quotas, handover to the next periods, and with the country caps. This is what is impacting accessibility of import market for you. And there are also other factors which you need to consider to check if you can import, and which will impact also the market in future. So handing now to Lars. Thank you for your attention. And
thank you very much. Thank you very much, Alexander. And please, for the audience, please do not forget to use the chat function in this webinar to address your questions. And again, passing over now to Lars Hillmann. Thank you very much.
Yeah, thank you, Alexander and Alexander. This was very interesting, and I will touch some of the points mentioned right now with the instrument. And I would like to start with the interconnection of safeguards and other trade measures. So it's perfect, Alexander, Siryk, where you left off. I will just start. And we will discuss what it means when I've presented this slide. So what we are looking at when we are looking at safeguards is protecting the EU producers. This is clear for everybody. And to do so, the EU has a lot of different, I would call it, weapons in their arsenal to actually make sure that the European market, where imports are concerned, is protected from unfair competition, that's countervailing duties and anti-dumping, and also what we have been discussing in the past weeks with the second Trump administration, rebalancing measures, also called countermeasures, etc. And there's one instrument that's somehow not fitting here, but I will just mention it because it's also a relevant factor for the steel industry. That's CBAM. These are, if you want, so all trade defense instruments to protect the EU market from imports that the EU legislator, mainly the EU Commission in this case, has decided is not to their advantage. And the regulations following from these instruments are plenty, and here are just some of them. And as you can see with anti-dumping, these are only, as you can see here, these are only regulations issued in 2025 only. So we already have 5 sort of steel-related measures coming up. Others are in investigation in the anti-dumping, in the area of anti-dumping. And our topic for today, the EU safeguards, it's actually interesting that in the history they have been applied to salmon and steel, and that's it. So the instrument has been there for a while, the idea of protecting the EU producers against the steep increase of imports. And with where we just left off with Mr. Siryk, it's very interesting to see the development of the EU safeguards since 2017, when the discussion started, until now. It's almost 8 years over. Next year we will have the 8-year period fulfilled. So these safeguards have been there for a long time, but they are designed to only last, and this is WTO law, they are only allowed to be put in for 8 years. So, and this leaves the question, once we are hitting 2026, and we all need to prepare for 2026 at some point, what will be the instrument that follows when the EU safeguards are no longer applicable today? But there is an interconnection between the countervailing subsidy, anti-subsidy duties, anti-dumping duties, rebalancing measures, and you have an entire, an entire library of regulations, if you want so, that follows from this individual instruments. And this is what you have to track when you are importing. So you usually use, in Germany, you use the EZT, the online customs information system, or you use the Cattwyk system. You find out which one applies, and then comes the question, if I have a steel product that falls under anti-dumping, and it falls under EU safeguards at the same time, what do I need for my price calculations? How do I need to factor in the risk? Is it actually worth it importing this product? And this is what I wanted to touch upon now. Each instrument by law is designed to be lone standing. So meaning if you don't have a special provision in the law that says that one instrument takes precedence over the other, then all these instruments are applying at the same time. And this is what you need to factor in when you plan your imports, when you plan your purchases. So, and it would be very easy if there would be one regulation or one rule to apply, but this is unfortunately not the case. In the past, the EU used one instrument, a regulation 2015/477, and some implementation regulations to list all anti-dumping measures that are set off against the EU safeguards, meaning that when you are actually paying safeguards on your import, 25%, and the anti-dumping duty on your product would be 30%, then 25% of the anti-dumping duties would be suspended, would not be collected, only the 5% on top, making it in total 30% of additional duties that you would have to pay. If this does not apply, it would actually be 25% EU steel safeguards plus an additional 30% of anti-dumping safeguards, making it 55% additional duties. And this would be an overkill and not WTO conform. So because this regulation was not updated in the past, so I think the last update was 2021. Yeah, here the last amendment 2021. The new approach is every definitive anti-dumping regulation contains a safeguard adjustment provision. And interestingly, in every anti-dumping procedure that you can see right now, some importers are raising concerns that when anti-dumping and the safeguard applies, that then this measure would be prohibitive and excessive. I was explaining that you have a set of mechanism between steel safeguards or EU safeguards in general and anti-dumping duties, but you don't have this with provisional measures, and the EU is always arguing that they might decide on a case-by-case basis whether or not they include this setting off mechanism or not. So when it comes to what Alexander Siryk said, we are looking what new instruments will be implemented once the EU safeguards have to or they run out, and according to WTO law, you cannot enact them immediately again. This would probably be one mechanism they can apply. They will not have this setting off anymore. So this is the respective article, just for you to read afterwards. This is one of the aspects where the interplay between the different trade defense measures comes into play, and what you have to factor in when making your purchases. Then we've already talked about the carryover and unused country-specific quotas. So I don't want to repeat too much. The interesting part from a legal perspective is that you actually have to trust that the EU Commission and the National Customs Administration is applying this carryover mechanism correctly. So it's an automatic calculation, but when you want to challenge this decision because you have the feeling my quota is depleted, but it shouldn't be, it is very difficult actually from a legal perspective to get access to this information and to actually challenge and assess whether or not this was applied correctly. So even though the transfer of the carryover happens by law, there is no legal remedy to actually assess it. It would be rather complex to find out whether this was applied correctly. If you find out that carryover mechanism or any other adjustment mechanism has been applied incorrectly, then you also have limited access to remedies. You can, of course, always issue an objection against your duty payment notice. However, you would have to do this within a month after receiving it, which is usually not the case because you might know about wrongful administration of quotas later. So the only way you can actually reclaim your duties that you have paid unlawfully would be Article 117 UCC or the 120 UCC, which in both cases is very difficult. However, there is one interesting decision from a German court of law, the Fiscal Court of Düsseldorf. They have actually allowed once an importer to get granted a repayment of safeguard duties after the quota was depleted and reopened in the next month or transferred to the next month, carried over. And then the Fiscal Court of Düsseldorf in Germany said, no, this quota has to be applied in the quarter where it originally was claimed. So the carryover already took place, but the court still granted for the old quota a repayment of duties. So far, I think this has been one exceptional decision on the matter. This is if you have the feeling that there is something wrong with your duty collection, this might be one of the ways to reclaim, but it's rather difficult. The second thing, the carryover is the one mechanism. The other thing is assessing the country-specific quotas, the residual quotas. There has been this change in law, what Alexander Siryk already presented. And there's, in my view, also certain room for error when it comes to applying this by the authorities, especially now as things have changed. And the same thing applies here. You are somewhat it's a somewhat intransparent procedure from the EU Commission when it comes to the individual importer. We all know how it works on the general level and how the system is designed, but we all have to trust to some extent that the EU Commission is actually applying this correctly. And if not, the legal remedies are quite limited. So if you have the feeling there's some, especially now after the amendments, there is some incorrect application of this mechanism, then my recommendation would be to file objections to keep the case open until the hiccups are clarified. What else is concerning about, from a legal point of view, concerning about the latest amendment? We have already talked about it. The liberalization rate is basically non-existent now. We started with 3%. Then the latest or the last year's liberalization rate was 1%, and now we have 0.1%. And if you look at the WTO agreement on safeguards, you will realize that liberalization is actually one key element of the public international law allowing WTO member states to use safeguards. And what we are seeing right now is that the EU has successfully argued at the beginning that the steel safeguards are necessary and compliant with the WTO laws, but then instead of or let me reframe it, then from this point in time, 2018, the WTO would have expected the regulations or the international public law would expect the EU to reduce the scrutiny of the instrument. So that's where liberalization comes into play. That's where time bars come into play. So you need to justify if you want to extend the measure and so on. But what we've actually been seeing is that the instrument was tightened every time it was amended instead of liberalized. So this raises questions whether or not, if it would be taken to the WTO, whether or not this instrument would actually be held compliant. For you as the declarants, if you are importing, this isn't immediately helpful. You cannot place an argument in your objection procedure vis-a-vis your customs authority based on WTO non-compliance, but it might, in the end, lead to retaliatory measures, or in case the EU agrees at some point for settlement, in another amendment of the instrument. So this is something to watch out. So far, at least what I've seen so far, there is yet no discussion to take this matter to the WTO dispute resolution body again, but we will see how the other states react. Then another, now away from WTO law, applying EU law, we have also inconsistencies among member states or between member states. This is, I think, known in the market, and this is also a legal issue. Some member states allow their importers to launch customs declarations and later withdraw them, leading to the fact that already used up quotas become available again later, which may lead to windfall profits for people who are imported later and already factored in the 25% tariffs. And the big question always is, how do you get back your duties that you have paid, the safeguard duties? And currently the system is applied in a way that gives every declarant the chance to reapply for the reopened quota. And I was mentioning the judgment by the Fiscal Court of Düsseldorf in Germany. If you read this, one could actually interpret it a little bit different and say what matters is the time of import and not the time of reopening the quota. So the big question is the EU actually applying the law correctly here? And so far we have not seen decisions on this, but from a legal perspective, we would think you can as well argue that a reopened quota because of giving back or withdrawing a customs declaration has to be applied to the first come, first serve people, to the first declarants who actually applied for the quota. This is one issue that has been there all the time and I think will stay with us for a while still. So question is, with all these insecurities, you don't know at the time of import, will the quota apply? Will it not apply? Will other trade defense instruments apply? Then we have also seen in December, it was announced that there will be an early revision of the safeguard measures, leading to relatively fast implementations of new measures or adopting new quotas, reducing quotas. So for the ones of you who already had longer lead times, this brings you into a situation where you might have to fulfill your contractual duties vis-a-vis your customers, and you have already agreed on a fixed price, which is, in my view, when it comes to steel imports that are affected by anti-dumping, by steel safeguards and CBAM, currently not a good idea to actually grant fixed prices. Even though customers usually expect it. Why is it not advisable? Because you have almost no legal remedies under private law vis-a-vis your customers to claim for additional duties. For the ones who think they can use force majeure or hardship clauses in their contracts, it's often very difficult whether or not this contractual clauses actually apply to the situation, because it's not force majeure if a regulation is amended that was to some extent foreseeable. The same applies for the jurisdictions where you have the right to claim an amendment of contract, which is true for German law, for example. If the conditions of your agreement change to a certain extent, you may ask your contractual partner to renegotiate. But this is usually not applicable because duties and these regulations are known before and there's a risk distribution. So what the solution would be, and that's something maybe to think about when you are looking into your contracts, you will most certainly not have the chance to convince your suppliers to come your way with price reductions when the tariff quotas apply. So the only way you can deal with that is cost-sharing clauses, flexible cost-sharing clauses or quotas with your customers. And the other thing is, if you don't know yet how high your costs will be, there's also always the option to include renegotiation clauses into your contracts, make them very specific on under which conditions you want to reopen the contract, because you also don't want your customer to have too many chances to open the contract for negotiation. This is something we usually advise to include. The cost-sharing clauses have the benefit that you already agree on a mechanism and then you only need to apply it. There is no further discussion. Renegotiation clauses, you will still not know what the outcome of the negotiation will be. So this requires a little bit of trust with your customers. One last thing on the contractual side, because we see every once, or not every once, we see it very often that companies are using terms and conditions to actually safeguard against safeguards or CBAM. And when it comes to show when you need to apply these clauses, the first question always is, do my terms and conditions actually apply? And there's a 50-50 chance that they do not apply. This is unfortunately also not fully harmonized within the EU. So even with EU customers, you cannot say, okay, I have an Italian customer, the terms and conditions will apply under this and this, or both will apply. You have very different traditions in the member states. So when you use terms and conditions for such relevant, price relevant questions, there's always a risk that you might actually not come through when it comes to show and when you need to take the matter to court. So this is something, in my view, that needs to be put in price clauses directly when you are negotiating what part of your price is fixed and what part of the price you can is not yet calculatable. So what do you need to include later? So that's my take on the EU safeguards and its implementation and amendments. And yeah, I would say I'm happy to answer questions.
Yeah, we have a couple of questions here. My first comment is that I think that with all what is coming now, that means the safeguards, but also CBAM, that the bond within the supply chain, that means also the bond between the declarant and the distributor and the final user, is needed to become closer. And that means, just besides the legal implications, that we will need to move closer together within the discussion of pricing. Again, we have a few questions. Some of these questions are have a more economic background. For example, what is the impact of these measures on the downstream industries and inflation rate in the EU? I think it's very difficult to answer. I don't know if Alexander in particular might have an answer to this.
That was what was always discussed, because this protectionism topic is my specialization since the last 30 years. And that was always a discussion, because it's finally end user is between the forge and the hammer at the end. And this has implication in all the system, especially in this turbulent environment. It has a double effect, because many importers, especially processors in the European Union, they are really confused by the situation where they are not sure about import conditions of the pre-material they need to bring for their processing, and so for input material, and at the same time they are not sure what is happening with end using market. For example, if you buy something from Asia, which you use as some parts, and you have some time lag of 4, 6, 8 weeks when it is arriving, and you need to optimize your logistics, so you need to buy the volume, then you bring it to Europe, you need to process it, and then you are not sure if you are able to sell it, for example, to your American market. And this is one of the negative parts of this story. But inflation rates, there are multiple factors which are impacting inflation rates, and this is not the only one. So the safeguards for industrial products, it's not the only factor which impacts inflation rates. So it's therefore overall effect is quite negative, but I also have seen, I think that Alexander will address this question as the next one, about also impacts on competitiveness and so on. And this is what we need to bring into discussion altogether, because there are also some interesting parts of this.
Thank you, Alexander. Then there's another question about the reports of the European Commission. That means on the internet, where you can see also the allocated percentage at the exhaustion date for any order number under the EU safeguards, and where it can be really, if these numbers can be taken into consideration, how seriously. And also from the example which was taken here from from our audience, there is actually in total awaiting allocation of 0, with the last allocation date of 22nd of April. So from my understanding is that after the 22nd of April, there is no further allocation registered or not registered yet. Is this correct, Alexander?
Yeah, I checked also the same link, and this means that there is no volume remained anymore. There is no volume remains for this order, and basically that's it. So it's 0 is indicated because all volume is consumed for this order number. So this is the import of specific tubes from Turkey, and it has gone already.
And perhaps an additional question also into the direction of Lars Hillmann. Those tariff quota details which are displayed on the official website, can they be taken for granted? Is this secure? Are these indications how it is legally seen, and what is the legal commitment from the European Commission towards those displayed numbers?
So from a legal perspective, this is merely an information. So the EU gives an information that on the 14th of April, the tariff quota has been exhausted. So that's the last day where there was an actual allocation of quota to declarants. Now comes the problem. You can track this, and that's what Alexander Siryk also said. You can track how the quota was used day by day on a daily basis. But what you cannot do is you cannot know, did they actually factor in all the customs declarations correctly? Have they maybe done a mistake there? So from a legal perspective, this is merely an information. And if you have the feeling that something was wrong, that somebody's customs declaration has been accepted while it should not have been, or some customs declaration was withdrawn and you don't see it reflecting in these numbers, then the next step would be to ask for a disclosure of the underlying data. And this is what I meant with we have a lack of transparency. We actually have to sort of trust these numbers, and I as a lawyer don't, please forgive me, I usually do not trust the EU Commission or customs. So if you have the feeling that there has been wrongful application of the duties, in my view, the burden of proof lays with the customs authorities or the European Commission to actually show that these numbers are correct. Does it help you in practice on a daily basis? Probably not, because it's rather difficult to fight this through. So it needs to be actually worth it to go down this rabbit hole.
Thank you, Lars. And let me just add another question, which is going into the same direction, or let's say into the direction of harmonized customs procedures that you also mentioned. And the Italian system is a question if now the Italians are under pressure to have their system changed in view of, let's say, also the valid procedures or the general procedures which are applied in the rest of the Union.
Yeah, so, and this is exactly the problem. As long as you have a different application of procedures, you have the 2 or 3 days gap in between. So you can, in this case, because of one member state not following the procedure that the others are doing, you cannot fully trust the quotas. And this also leads to hiccups when it's in the system. So we have seen that then the system shows it's depleted and then it's reopened again. And now the question is, should it not actually be reopened at the day of the customs declaration that was withdrawn, and not at the day when the customs declaration was later, or the quota was later handed back? So yeah.
What I may add from our side is that TaxSuit, that means DG TaxSuit, is working on an adaptation, on a kind of a harmonization. The current rules, that means the current law, is still permitting this procedure, which is being practiced, and to what extent it is being amended, we will see. It's not declared. It's still under discussion. So then There is another question about carryover quota, which will be discontinued starting from the third quarter of 25, but for before mentioned categories, but now in Q2 carryover is still effective. I think it was answered, but perhaps Alexander, you can still answer this one.
You saw this on the slides that there is a carryover of volume for the current period. So you effectively see that it was allocated some weeks ago. So, and from the regulation perspective, Lars, please correct me if I'm wrong. It is really start of the period is the next quarter period. So it's
yeah, that's also my understanding.
Yeah, some questions are going here into the same direction of exhausted quota. I think it was basically answered. Nothing is secure, nothing is safe, and we all have to keep a close eye on that. Yeah, I think we are now fine in terms of timing. It's 12:06. I thank you very much for participating in this first webinar. I think there's space for more to come, and particularly with the changing regulations and also new regulations. I think CBAM is an interesting one. Perhaps we can plan also a new webinar on this. Thank you very much for your attendance, and thank you very much for Alexander's and for Lars' very interesting reports and making us all a bit more clever. Have a great start of the week. Have a great Monday afternoon. Thank you very much, and yeah, ciao for now.
Thank you for the invitation.
Thank you.